For our story, we have the case of federal judges, or any judge, but really this is federal in this case, sentencing you to crimes that a jury found that you did not commit, crimes to which you've been adjudicated. So to make clear how this could happen, when you're convicted of a crime, any crime, there's statutory limits on what can be given. There might be a statutory minimum, and there might be a maximum. And so there's a range of sentences a judge can give. And so there's say the statute says, just for the sake of argument, somewhere between 5 and 20 years is our range, okay? So anything within that is statutorily proper. And when the judge is considering where to put you in that, in the federal case, they have these sentencing guidelines that considers, your prior offense category, it considers the seriousness of this particular offense, and it considers other sort of mitigating and aggravating factors. And there's things that the judge can and cannot consider. And one of the things that the courts have allowed to be considered in the past is other crimes. Now, the idea here is that while not enough to convict you beyond a reasonable doubt, there might be enough evidence to say that it's substantially probable that you committed the offense. So while we can't convict you for that offense, in consideration of the sentence of the 5 to 20, the court sometimes will bump that up based on other crimes that you've been acquitted of. But because they're putting you within the range of that statute, there's no violation of law. The law allows for 5 to 20. So if they say, well, I'm sentencing you to 20 years, it's within the range. So the question really is, well, can they consider this factor or not? And the law certainly has allowed it to date. But United States Congress is reconsidering this. They are proposing a bill that would take this away from federal judges. So let's read this article and read what's going on here and try to learn a little bit something about the acquitted conduct doctrine and how it applies in federal courts. Can a federal judge sentence you to a crime your jury says you didn't commit? In a sane world, the answer would be no. If a prosecutor charges you with 5 crimes and the jury finds you not guilty for them, the judge who doles out the sentence should be able to consider only the one guilty verdict. Yet federal judges can and often do with what's called acquitted conduct charges for which a person has been found not guilty. We're sentencing defendants for the crime a jury says they didn't commit. It's a horrifying bug in the criminal justice system that doesn't get enough attention until now. Senators Dick Durbin and Chuck Grassley, so this is bipartisan, so that's nice to see some bipartisanship, right? That's still going on somewhere, introduced a bill this week that would expressly prohibit the use of acquitted conduct in sentencing. If any American is acquitted of charges by a jury of their peers, then the sentencing judge should not be able to find them guilty anyway and add to the punishment. This is not acceptable and it's not American. The power of acquitted conduct is a deadly arrow in a prosecutor's quiver. The fact the judge will consider at sentencing every offense the prosecutor charges, even if jurors don't buy the prosecutor's pitch, essentially allows prosecutors to game the justice system. They can charge a defense with an offense they know that they can prove beyond a reasonable doubt, and then charge more serious offenses with tougher penalties that they can't prove. And even if a jury acts responsibly by convicting only on charges proved beyond a reasonable doubt and refuse to convict on other charges, the prosecutor still wins when the judge takes into consideration all the charges during the sentencing. Very fair point. Under our Constitution, defendants can only be convicted of a crime if a jury of their peers find them guilty beyond a reasonable doubt. However, federal law inexplicably allows judges to overturn a jury verdict of not guilty by sentencing defendants to acquitted conduct. Now, as I was saying in the preamble, it's not strictly speaking correct that it allows them to override the jury verdict. That's not exactly what's going on. It's not that they're being convicted of the crime. It's that in determining the sentence for the sign they've been convicted of, they're considering factors that relate to offenses for which they were not convicted. So it's not quite a correct statement, but I guess close enough for our purposes. A laundry list of criminal justice reform groups support the Durbin and Grassley bill, titled Prohibiting Punishment of Acquitted Conduct Act. The bill would amend the federal criminal code to preclude a court of the United States from considering, except for purposes of mitigating a sentence, acquitted conduct as sentencing. I do like that one-way ratchet. So I do like the one-way ratchet. It's saying, you can only consider this as mitigation. You can't consider it as enhancement. So that's a nice touch. So that's really good. That's a really nice touch. And it would define acquitted conduct to include acts for which a person was criminally charged and adjudicated not guilty after trial in federal, state, tribal, or juvenile court, or acts underlying a criminal charge, or juvenile information dismissed upon a motion for acquittal. The bill has support from several libertarian and conservative groups, including Americans for Prosperity, the American Conservative Union, American for Tax Reform, Freedom Works, Prison Fellowship, and the R Street Institute, Right on Crime, and Koch Industries. So all you people who hate the Koch brothers out there, I just want you to know the Koch brothers are trying to make it harder for criminal defendants to be sentenced to crimes. So, hey, that's the thing that they're doing. Just take note. It's not hard to see why the bill has bipartisan support, but to understand why the practice exists at all and why some people will inevitably oppose this bill, it helps to think of the criminal code as a choose-your-own-adventure book in which 3 out of every 4 narrative choices end in go to prison. That's snarky and cute, and I like that. Police and prosecutors want to keep it that way. The use of acquitted conduct in sentencing empowers prosecutors at the very early stages of the justice adventure. Upon gathering enough evidence to make an arrest, the prosecutor can file charges that, if the defendant is convicted of all of them, he or she would go to jail for a very long time. So the prosecutor encourages the defendant to plead guilty and receive a lesser sentence, staring down the barrel of a 20-year prison term if they lose a trial versus 10 or 5 if they plead guilty. More than 95% plead guilty. But what if the defendant didn't do everything that they were accused of, or the prosecutor against them was weak? Well, they can take the case to trial and have it before a jury. Instead of 20 years in prison, or 10 or 5, maybe they're acquitted and get no time, or is convicted of only a fraction of the charges and spend 2 or 3 years in prison. And that's where acquitted conduct comes into play. Prosecutors can lose before the jury and still win in sentencing. Using acquitted sentencing to set sentences highlights the temptation of prosecutor overreach by blunting the downside to the government. If the defendant succumbs to the government's aggressive charges and pleads guilty, the government wins. If he goes to trial and is convicted on those charges, the government still wins. And if he goes to trial and persuades the jury that he's innocent of all of them, the government wins, so long as he secures a conviction on the most easily proved offense and then persuades the sentencing judge of the guilt by preponderance of the evidence, which is to say more likely than not, which is to say 51%, which is to say well less than beyond a reasonable doubt. When acquittal of certain counts as a speed bump in sentencing, prosecutors have little to lose by landing an indictment with charges they cannot prove beyond a reasonable doubt. The government has conceded as much, acknowledging that punishing acquitted conduct encourages charges of prosecutions that they would otherwise forego. This is a bad practice. Thankfully, it's one Congress appears willing to address without waiting for the Supreme Court. So that is something that you might not have known, that the judge, when determining your sentence, can consider things for which you were acquitted. And Congress seems to think this is bad, and there's a bipartisan push to do it. And many of the groups that are backing this are libertarian and conservative in nature. So for those of you who are more left-leaning, it appears to be, at least, that there are a lot of conservative libertarian groups that are doing this. And, thank goodness for that. I think that if you're acquitted, that should mean something. I'd also like to take note that I think that this will actually matter in the real world. There was someone who had asked me one time if I thought it would matter because judges might still do this but not declare their intention to do so. So they might hide the ball. They might secretly be saying, they might secretly to themselves do it for the improper reason, but when they write their decision down, they have to come up with a proper reason. To that, I would argue 2 things. First, practical, and one philosophical. The practical is, without this rationale, it becomes harder to justify the reason. When you deviate from the sentences in the sentencing guidelines, you have to justify that rationale, and you have to provide a reason. And without that tool, it becomes much harder to provide the reason. But let's suppose they could anyway. Let's suppose they could do it anyway. My second argument here would be philosophical. I really believe in my heart that most federal judges want to do substantially the right thing, and they want to follow the law. Most judges believe in their oath of office. They believe in their duty to the Constitution. And if Congress passes a law that says something, I believe that most of them will strive to follow it. The law as it currently exists allows for this. Maybe they should, maybe they shouldn't. But there's nothing inherently dishonest about judges doing this because the case law currently allows for it. So if a judge is doing this, they're doing it in compliance with the law. So I think most judges out there are very honest people and will say to themselves, okay, Congress has said that I can't do this, and they will in fact strive to not do it. So I think the risk of federal judges circumventing this by trying to hide the ball of their motives is less severe than it appears. So I do believe that this will make a substantial difference in the real world as judges become more used to this. And I think it will make a difference in terms of how prosecution goes. So I think it will be net positive, and let's hope that bipartisanship wins someday and this becomes a law. So we'll see what happens next.